Hi, I'm Greg Dell here with Cesar Gavidia. And Cesar, I want to talk to you about these new Department of Labor ERISA regulations. And it started back in, actually, it's been going on for years.
Yeah.
And in December of 2016, the Department of Labor said, guess what? We have these new rules and we're trying to protect consumers. I mean, they're trying to make it better for claimants. And then they took a lot of comments and feedback back and forth. And then finally, April 1st, 2018, the new regulations went into place and they said all the insurance companies had to be in compliance with these new regulations. So we're only filming this video in August of 2018, so it's only been about coming up on 5 months of these regulations being in place. So I want to talk to you a little bit about one particular aspect of the new regulations and how we are starting to see some companies implement them and what kind of impact we think these changes are going to have.
Mm-hmm.
So one of the biggest things that was going on was the improvements to the disclosure requirements. Mm-hmm. And basically what that is, and obviously we're only talking about ERISA claims, is what information does a disability insurance company need to give to a claimant in the initial stage when they deny a claim and then again on appeal. And there's lots of things that were changed, so I'm going to go through a few of these and we'll discuss, what impact we think this change is going to have and if we've seen anything yet at all. So the first one is saying that when you get a benefit denial notice, mm-hmm. it must contain a complete discussion of why the plan denied the claim and the standards applied in reaching the decision.
That sounds like familiar language. It sounds like what they were supposed to be doing in the first place. Completely disclosing the reasons for denial and explaining why that person specifically being denied so that they could appropriately address it through an appeal. So it sounds almost like they're saying you have to just keep doing the same thing.
Well, yes, I mean that is what they were saying beforehand, but I think what happened is they when they opened this up for public comment, they got about 175 letters from insurance companies, from lawyers, from the advocate groups and all of that stuff. And basically what they said is this is a problem, that these denial letters, and how often do we get these 1 or 2 page denial letters
vague
that
and have no information,
basically say nothing.
Right.
So the idea is they're saying, look, you need to be more complete. Whether or not we're going to see a change, I doubt it. I don't know what you think or what you're starting to see. Every company is going to be different. I think it's still too early. I'm not seeing much of a change yet. I don't know what you've seen.
Well, I could tell you that there are companies that, we're getting recent denials on, that the denial letters seem just as vague as they were pre-January 2018 when the regulations went into effect. So in terms of more completeness or more detail explaining why the person is not entitled to benefits, I'm still seeing, and we're still seeing, the medical records don't support your restrictions and limitations. Not explaining what in the medical what they need to see in terms of what type of restrictions and limitations should be imposed, what their doctors and the physician consultants that they consult are specifically opining. Sometimes they don't even give the identity of that physician consultant. They're still doing that. So in terms of...
Well, that's going to segue us into the other thing that they said. But, everything we're going to discuss today is going to take months, if not years, to play out.
Right.
Because so these regulations went into place April 1st, 2018. So that means it doesn't apply to anyone until anyone who was denied after April of 2018. And then anyone denied after April 1st of 18 has 6 months to do an appeal, which goes to October of 2018. And then if they deny that claim, we're first going to be filing lawsuits at the end of 2018. And by the time we get around to the courts and asking them to, enforce these new regulations against the company to determine if they acted unreasonably or violated the new procedures, we're not looking till opinions on this new law till late 2019.
Right.
At the soonest, and that's in the district court. Then if they're appealed, we're not going to have any appellate law on this till 2020.
So you're looking at actual binding opinions at some point in 2021, 2022, maybe 2020.
Yeah, well, I'm hopeful it's 2020, but we'll see. So let's segue into the next one where you mentioned that they don't even name who the doctor is. And the next regulation change was the basis for disagreeing with the views of healthcare or vocational professionals whose opinions were provided by the claimant or obtained at the behest of the plan, regardless of whether they were relied upon in making the claim determination.
Mm-hmm.
So basically that's saying that they have to provide a basis for why they disagree with the plaintiffs or the claimant's doctors and or the vocational rehabilitation.
Yeah.
Now, if this happens, it would be shocking to me because it's rare, in my opinion, that they comment other than just list the records.
Right.
Well, what do you think?
Yeah, I think you're right. Yeah, they basically regurgitate the medical chronology, the medical records, the medical history, and they really don't address specifically what distinguishes their doctor's opinion from the claimant's doctor's opinion.
Right, because it says right here the basis for disagreeing with the views of healthcare, and what they added here was vocational professionals as well.
Right.
As a tip to anyone who's watching this, and some people choose to do their own appeal, is, if they got to respond to all of this, you better try to get as many doctors as you can to
Yeah.
give opinions, and voc rehabilitation reports are going to become that much
Right.
more important.
And the other thing is, and I think people need to be aware out there, that if they are pursuing the appeal process, I don't see any claims, any appeals being done within that first 45-day period that they have to decide these appeals. So expect that it's going to be extended to those 90 days.
Right. So we'll see how that plays out, but I'm definitely going to really possibly increase the doctor support and consider a lot more voc rehabilitation
Absolutely.
reports. It also says, which is something that was out there from case law, but now they've kind of codified it into the law, was they have to provide their basis for disagreeing with a finding of disability by the Social Security Administration.
Mm-hmm.
How many times do we see the language that just says, "Oh, their standards were different than ours, therefore we're not going with that"? I don't think that's not going to fly anymore.
It's not. And, quite honestly, the fact that they have to now specifically explain what is different, I've never seen in one denial letter them address Social Security disabilities, independent physician consultant that is, that not even retained, that they go out and do a complete review of that claimant's medical file, their medical history, the restrictions and limitations. I've never seen them once address that. So it's going to be interesting to see it now, if they do.
And it's going to be important to get the Social Security file. And keep in mind, you may not know this, well, you know this, but they may not know this. It can take quite a while to get the full Social Security file.
Right.
Sometimes months, unfortunately, to get a complete copy
And
of the file.
I did see just recently in an appeal that I'm handling, the disability insurer say, we need extra time because we're requesting the Social Security file. That used to be on the claimant to provide. That was their responsibility. In this case, and it still may be, but the disability insurer is actually proactively going out to obtain that Social Security file.
Right. I still think the claimant has the burden of getting it.
I agree.
But
Yeah.
if they're asking for it, then the next part of this improvements to disclosure requirements is that the benefit denial notice must contain the specific internal rules, guidelines, protocols, standards, or other similar criteria the plan relied upon in making the adverse determination, or a statement that such guidelines do not exist. And that statement used to only come in the denial letter after the appeal.
Mm-hmm.
So that's a big change because a lot of people call us, well, not a lot, but some people call us and say, I did my own appeal. Mm-hmm. And they never got any of the protocols, the guidelines, or anything that the carrier relied upon to make the determination. So now, basically, all the claim handling and everything that the disability carriers rely upon, they're going to have to tell them right away in that initial letter, hey, this is available for you. And the companies are going to have their act together and provide all of that stuff.
And the reason that's important is because if there is some departure from the procedures and guidelines that they have in place, that could be the basis to finding that they acted in an arbitrary and capricious manner if it has to go beyond the appeal stage into litigation.
The last one, which is interesting, is it says benefit denial notices must contain, if the denial is based on a medical necessity, experimental treatment, or similar exclusion, an explanation of the scientific or clinical judgment for the determination or a statement that such will be provided free of charge upon request. So we almost never see that.
Never.
Talking about the medical necessity or experimental treatment. I mean, we almost never get anything on that. So I don't think we'll see much of a change on that. But these rules, which was funny, when it came out from the Department of Labor and you look at their intent of what it was, and they say, the new rules add important procedural protections and consumer safeguards for claims for disability benefits. They protect claimants from conflicts of interest, increases transparency, and ensures that claimants have a fair opportunity to respond to the evidence and reasoning behind the decision. The rules also ensure that protections for disability claimants parallel protections that already apply when workers file claims for group health benefits. Mm-hmm. So that's the goal. That's language straight from the Department of Labor. That's not our opinion, which may be sometimes biased because we always help claimants. So, you know, that's the intent here. That's what's going to be in the Code of Federal Regulations for Section 503. And those are things that we're going to argue in court documents to say, Judge, you know, this is not what it was pre-April 2018. This is a new, hopefully tilting the scales more towards the claimant, that this has to be fair, this has to be transparent, they have to act reasonably. They can't try to hide behind this curtain and talk like it's the wild, wild west of how they're going to evaluate a claim.
Right.
So, you know, they didn't go as far as getting rid of discretionary clauses, which we would have liked to have seen them do. But I think they're heading in the right direction to try to make it more lax and better for claimants.
I think so. And I was surprised not to see that as well. Because there are, as you know, a number of states. I think we're around 11 or 12 states now that have banned the discretionary clauses.
Right.
And we really need uniformity there.
Right.
Uniformity in the sense that it's banned across the nation, because it's what tilts the scales in favor of the insurance company in almost every case.
Right. Well, we're going to watch all of these regulations as they progress, and we're going to continue to report on how each company is implementing these changes so that claimants around the country can be aware of what's going on and hopefully help them to continue their claim or help them out with their appeals if they get denied. We're going to do some other videos about some of the other changes that have been made to the regulations and how we think that will impact claimants. Again, overall, I think this is a good thing for claimants. I'm hoping that it will help as much as the Department of Labor intends for it to. If you have any issues with any disability insurance carrier, whether it's short-term or long-term disability, feel free to call any of our attorneys. We always offer a free initial phone consultation, and we welcome the opportunity to speak with you.